Because you have to understand, a court of record is also what you would say is what the common term is like a court of record. You're basically saying it could be a traffic court, it could be a mortgage court, it could be admiralty. They're going to record the event that happened. So unless you say in this court of record at common law, or you say law, common, law, common, what type of law are we at? Are we in traffic law? Is this admiralty law? Is this natural law? Is this absolute law? What law is this? And law is just the customs and the practices of the people in society who agree to a certain terms and conditions to abide by. So when you go to traffic court, it's their law, it's their customs, it's their beliefs, it's their practices that you're standing in. This is where you're residing. So you're at that law at that particular moment in time.
Yeah.
But it's on the law. So just because you say it's a court of record, everything is being recorded, but you have to expressly state that this is a court of record. And my belief, and it's also backed up with Black's Law, 8th edition, 2004, operates only under the common law. There you go. Mm-hmm. You can say court of record, see Exhibit A. And then the judge flips to Exhibit A. Well, according also not only my belief that it operates under the common law, in which I have the right to have a trial by jury, and the magistrate is independent of the tribunal. It also established, well-established fact on Black's 8th, 2004, page 522, court of record.
Well, I can continue. When they put me on, when my ex-wife put me on the witness stand to examine me, she goes, well, I hear you're one of those sovereign citizens. Do you want to expand upon that? I said, well, there's no such thing as a sovereign citizen. You're either a sovereign or a citizen. I consider myself a sovereign. And the judge smiled at me. Right when I said that, he smiled. And I knew I owned that court right there at that moment. That was my court.
Well, what you did was not truly a court of record common law. What you did was you were doing a dance for the Dancing with the Stars and the judges or Simon Cowell, and Simon Cowell was giving you a thumbs up or thumbs down. In common law, that guy in a black robe has nothing to do with anything. You established a law. You're bringing the claim. All he's doing is witnessing that nobody brought a claim forward from the other side. And if somebody did bring the claim forward from the other side, then you're going to hold a trial.
Well, she didn't really bring anything. I had my affidavit. She had nothing else.
Well, then there was nothing for you to say. Until she puts it in writing and brings it and answers the claim, how did you even get to the point of a trial if she didn't answer?
Well, it was basically a summary judgment, and I just said, look, if I don't get what I want, and I said on the witness stand under oath, if I don't get what I want, we're going to jury. So that's all there is to it. And the judge smiled at me and winked, and he said, and basically right there, he said, "You're getting it."
Oh yeah, because that's fine. I was just trying to figure that out.
And you know what? If she would have demanded a trial by jury, she could have had it. Because I declared it a court record. We're two combatants.
Well, whether you
not using swords, but we're combating in court, and a jury will decide. And she did not demand a jury. I got what I wanted.
Well,
I didn't proceed any further.
I said, I wasn't there at the time, but like I said, obviously, did you file divorce? Did she file for divorce? How did it go down?
Well, this was after the divorce. We'd already had custody settled at 50-50, and then she wanted more time.
Okay.
She wanted to take away time that we've already settled in court, signed by a magistrate, and she didn't. She disputed that later.
Okay, wait a second. You got to stop, because this is convoluted what you're saying here. You already had an agreement established at 50-50 rules between you and your wife, correct?
In the divorce, yes.
Yes. Okay, stop. What happened then is she wanted to modify again. She wanted to modify the order, you're saying?
Yes.
Okay, and she wanted 70% of the time, you're saying?
More like 90.
She wanted more 90. So where did she file that amended to request or a grant or whatever? Where did she move to court? What court did she move to amend the order?
The same district court that we had the magistrate.
When she wanted 90, that's it. That's stop. It's fine. It's simple answers. When she wanted 90%, did she send you a proposal, or did she verbally say to you, "I'd like 90%"?
Well, she didn't say to me. She said to the court.
Okay, so
more time.
No knowledge until you were summoned to appear in court that she would have liked more time with that child.
Well, she had verbally told me she she wanted more time, and I said, no, I disagree.
Okay, that's fine. That's fine. I just need simple answers here. So when she made a proposal to you of 90%, you said that's unacceptable. I still want to stand by the original 50-50. Then she, I guess, okay,
the agreement we signed on the divorce agreement.
Okay, it was 50-50. Right. Okay, so now she wanted to modify that contract, right, or that agreement, right, or that order, right?
Yeah, and take it to, I get every other weekend or something like that, like every other weekend.
Now, stop right there. See, this is what I'm trying to help you, because what you did was way overkill. You did not have to do a damn thing. The answer would have been as simple. There is an order standing. It could be a foreign judgment order. It could be wherever she filed it. It could be she could have lived in another state. There is an outstanding order. At this time, I do not wish any third party intervene to modify, alter, or change the original order that was established in whatever year you got divorced, 2002. I don't care what year it was. All you have to say is at this time, I do not see any benefit. It would not be beneficial for my person to alter or change, modify, to accommodate that person's wishes or demands. The order is to stand as it was written. It was written, let it be done. Period. There is nothing else to say. You don't have to go up on a court. You don't have to do court of record. You don't have to do none of this stuff. Nobody's allowed to.
Because she's filed again, and she wants to take away some time again. And I'm thinking I'm just going to...
So now you go back to the original order, and you just show to whoever believes they have the capacity to see and judge this and modify it. You just go back and say there is an outstanding order. I am not wasting, because if you open your mouth and you start saying sovereign citizen, say what third party impartial intervener.
Well, she started saying that when she had me on the witness stand, and I said, wait a second, a sovereign and a citizen is an oxymoron. Which do you claim that I am, a sovereign or a citizen?
What you do is you hold that order from 2002, the divorce decree, and you hold it in front of the judge's face, you hold it in front of her face. What does that say? 50%? What does that say? 50%. Do I want to renegotiate this order? No. Did you sign this order? Yes. Did you consent to this decree? Yes. I do not wish to amend, modify, or alter this document in one shape or form, and nobody on this planet can force me into a negotiation, and I'm not going to do it. And you keep saying, can't do it.
The original court was in error, and they can't be. They can't call themselves error.
She is the one who signed it. Her name is on it. She's bound by it. There's nothing you can do. You gave your word. That's stop it.
Her attorney and her signed it. I just signed it myself.
There you go. The deal is done. Let it be written. Let it be done. No more appeals. This is no rehearings, no redos. Go read the Seventh Amendment. Go look at what Marsha Clark is kicking herself in the butt. If she found 10 witnesses now who saw OJ do it, she can't retry him. There's no rehearing. It's done. You had your day. Your trial is done. Now get the hell out of this building and leave me alone and 50-50 the whole time.
Get the hell out of this building. I like that.
It's simple. It's done.
So the original order, that's it.
There's nothing wrong with the original one.
Never die by it. That's it. That's it.
Right. Nobody can intervene in nobody can intervene in a contract. Nobody can intervene unless you...
It's a contract signed by her and her attorney and myself.
That's right.
And sealed by a magistrate in a court of record.
And we're done. It doesn't have to be fancy. It could be in a court of McDonald's. It could be in a court of the Happy Meal Park Club. It doesn't matter where the court was held. It's called a foreign jurisdiction. And me and Greg one night are going to talk about courts of foreign jurisdiction that are recognized every single place, no matter where you go in an English common law world.